for the Sheriff's Department. What do you want to make clear about the charges and about what happened with these gentlemen? Because they're saying that they did take the class, but they were um, basically dismissed early from the class.
Yes, ma'am. The, um, the Ohio Administrative Code provides that they'll have 12 contact hours in a 2-year period of time. The code, as I read it, is not definite in its definition as to what contact hours are. The way the present administration interprets it as contact hours is actual time spent in the classroom. They decided to take a course offered by Mr. Vigorito. Mr. Vigorito was an approved instructor by the Ohio EPA. They followed Mr. Vigorito's instructions. Mr. Vigorito gave them literature to study, and they took a test. At the end of that time, they passed that test, but they did not spend, for instance, if it was a 6-hour course, they may not have spent 6 hours of actual time in a classroom taking that course. They may have spent 2 or 3 hours. Because they passed the test, Mr. Vigorito gave them credit for the entire 6 hours. The Ohio EPA is saying that is improper, that they needed to spend actually 6 hours of time to get 6 hours of credit. And what makes it very difficult, there are national educational institutes that offer these same type of credit hours online, and these men could have taken those hours. But again, they don't spend an actual 6 hours taking that time. It is, they get credit for that course equaling a certain amount of time if they take the test and they pass it. Very similar to being in college and proficiency a course and getting credit for that course because you passed the proficiency examination.
But this instructor, has he been charged with anything at this point?
He has not been charged at this point in time. It is my understanding that the Attorney General's office is investigating that case.
Is part of their agreement to possibly testify against him?
Well, part of their agreement is if they're called subpoenaed before the grand jury or subpoenaed to court, they're to tell the truth, and the truth is basically what I have outlined for you at this point in time.
Did this gentleman teach other counties or other water departments these courses and also let them out early?
I don't know that. I would have to investigate that, whether he taught other courses to other different water departments.
Do you feel they're being singled out?
At this point in time, I do.
Okay.
What else was in the agreement? What else did your clients agree to?
My clients agreed to pay a fine of $1,000 to the Franklin County Municipal Court. They also agreed to pay $250 as an administrative fee for the diversion program. There'll probably be court costs tacked onto that. And they have agreed to pay $2,000 of restitution to the city of Youngstown. They were giving the option of whether to pay or to perform 50 hours of community service or to pay an additional $1,000 as in lieu of the community services to the Franklin County Municipal Court, sir.
Why not fight this? I mean, it sounds like you guys didn't. I mean, if they took the test, they got the information, they know what they're doing. Sounds to me like maybe some of them feel like they didn't do anything wrong. Why not fight it?
Well, there's 2 different burdens of proof in this case, and these men were charged 2 different ways. One way was the criminal charge you were present for today, and as you sat in the room when I was discussing all the preliminary matters with my clients, I told them that it was a global settlement with the EPA, the Ohio EPA, pending against them. In addition to this criminal prosecution in the Franklin County Municipal Court, there is pending an administrative action for an administrative hearing officer to revoke their licenses. If they would have their licenses revoked, they could never have them reinstated because we did a global settlement between the civil action and the criminal action. they're going to have a suspension for a period of 1 year of their EPA licenses, and then they will be reinstated at the end of that 1 year period, subject to satisfactorily completing the diversion program. So the burden of proof in the civil case is not as heavy as a burden of proof in a criminal case, so you have to be cognizant of what arena you're in.
Does that 1 year, that suspension affect whether they can keep working or not at the
No,
water
they
department?
they can keep working. They're allowed to keep working.
What's the difference between a regular misdemeanor and an unclassified misdemeanor?
Our state has these specific unclassified misdemeanors, and they're statutorily created, and they're far more severe than a misdemeanor, as you're aware of all your years of experience. Misdemeanors start with a minor misdemeanor, which is nothing more than a fine, and they go from 4s to 1s, which mean, and if it was a misdemeanor 1, it would only be a maximum 6-month sentence and $1,000 fine. Well, the state legislature created an unclassified misdemeanor in this case. It carries with it a maximum of up to 4 years, which would be served in the penitentiary, and a $10,000 fine. So these gentlemen were facing some very severe criminal penalties if we did not reach a resolution of this matter.
What's the deadline for completing the diversion part of it?
1 year. Yes, sir.
And are all of, I'm sorry, I didn't mean.
No, that's okay. That's why you heard His Honor say, I will see you all on February 27th of 2018.
And are all of your clients, are they still working, or are they, any of them retired?
No, sir. All our clients today are still presently working. A couple of the gentlemen have talked about they're going to retire sometime this next year. All right?